on item number 7. Your Lordship, conducting counsel Mr. K.C. Gautam is currently out of station. Lordship, I beg for 3 weeks' time.
You're for?
The petitioner, Your Lordship.
It's a joint request, Your Lordship.
Lordship, I'm appearing on behalf of petitioner in CRP number 21 of 2016.
And I am appearing for the petitioner in CRP 28, Your Lordship.
So both of you are asking time.
No objection, Your Lordship. Joint request, Your Lordship. Your Lordship, pursuant to the order dated 12/6/2023, an affidavit was supposed to be filed, and we had filed on the last date, but that was not reflected, Your Lordship.
Your file?
Yes, Your Lordship.
Let the matter be called up. I'll pass and see orders.
May it please, Lordship. Lordship, I beg to mention item number 17, Lordship. Lordship, I'm praying for 2 weeks' time, Lordship.
What is item 17?
17. Lordship, this is a teacher matter, Lordship.
Oh, this is some referrals.
No, Lordship. Teacher matter.
And pre-meet by petitioner. This is matter up to 2 weeks.
Highly obliged, Lordship.
Lordship, I beg to mention item number 9. This is a joint prayer, Lordship.
My Lord.
What is
That is, my Lord, that relates to the dismissal on the ground of, it's a BSF matter, my Lord, where we have sought for the proceeding which is to be, by which he has been dismissed from service, my Lord. I have received the proceeding, my Lord.
you have received?
So, yes, my Lord.
When do we have it?
Lordship, after 2 weeks.
On pre-meet by the respondent, not objected to by the petitioner. This is matter up to 2 weeks.
Lordship, similar prayer for item number 10.
You're also there?
Yes, ma'am.
Same.
This is pertaining to that ACP, non-ACP, my Lord.
Oh, right.
Assam Rifle, my Lord. So, my Lord has directed us to file a written argument. Written argument is ready, my Lord. So, it's next date we will be filing that, my Lord.
On pre-meet by the respondent, not objected to by petitioner. This is matter up to 2 weeks.
Obliged, Lordship.
To item number this 13, 14, 15, 16.
Yes.
So in this case, I yet to have the instruction in the matter, you will see. This was for compounding.
Yes.
The petition was there.
So,
So you will see ROC has been transferred now, so new ROC has come. So I was not in a position to take any
who
instruction.
has any application for compounding been filed?
So last
Who's
to
for the petitioner?
Mr.
Your Lordship,
Sir.
I'm appearing for the petitioner. Your Lordship, we have already submitted our application for compounding of the offences and it is currently pending, Your Lordship. We have filed it on 15/6/2023.
Okay.
The process is still pending, Your Lordship. Some time may be done.
On pre-meet by the parties, this is matter up to 3 weeks.
Your Lordship, a longer time may be granted. The process is pending, Your
So,
Lordship.
3 weeks time will be given to you.
Your Lordship, Your Lordship. Your Lordship, the interim order may be directed to continue.
In the meantime, the interim order pass will continue until further orders.
13, 14, 15 and 16.
Highly obliged.
May I be pleased, Lordship. I beg to mention item number 19, Your Lordship. I'm praying for 3 weeks' time. Senior counsel is still on leave, Your Lordship. Item number 19.
No objection.
On pre-made by the petitioner, this is matter up to 3 weeks.
Matched.
Your Lordship. Please, Your Lordship, I'd like to mention item number 6. Your Lordship, the conducting counsel is indisposed, so this matter come up after 2 weeks.
Your Lordship,
This matter has been heard.
Yes, Lordship.
I'm appearing on behalf of Miss Colney, Your Lordship. She's the counsel for the corporation. She's also on legs, Your Lordship, before court number 2.
So what do we do?
Let the matter come up after 2 weeks, Your Lordship.
We'll dispose of this matter. It's a 2015 matter.
Yes, Lordship.
On pre-made by the petitioner, this is matter up to 2 weeks.
Obliged, Your
Yes,
Lordship.
Lordship.
Lordship, I beg to mention item number 11. 11. This is a joint prayer, Lordship,
Your fault.
for the respondent.
Your petitioner.
I'm not the petitioner.
What is this matter about?
This is regarding service, my lord, appointment. Try to finish on the next date.
Appointment means you were.
What had happened, my
terminated?
lord, there was an advertisement. As per the advertisement, he had applied. My lord, initially his application was rejected on the ground of that domicile certificate is fake. My lord, that was not the fact. So, my lord, that was agitated before this honorable court. Now the honorable court also came to a finding that the domicile certificate is absolutely fine. So he should be allowed to continue in the selection process. But thereafter the selection process was carried forward, my lord. But however, he qualified in the written as well as the physical test. He qualified, my lord. However, when it came to trade test, my lord, he failed in the trade test. So, my lord, there are certain. We are saying that, my lord, that the fact that we had challenged this the domicile issue before this honorable court, they are already, my lord, we have attracted the wrath of the respondents. Apart from that, my lord, if we go into the case,
How can you attribute motive?
my lord, even assuming, even if that is not there, my lord, will if we go into the case, we'll realize, my lord, the manner in which they had carried out the trade test. So those issues, my lord, I have raised in my rejoinder. So, my lord, there I can show, my lord, that there is some element of bias is definitely there, my lord, unfairness biased. So, my lord, we'll try to, my lord, finish it on the next date.
So when?
We come up.
After 3 weeks, Lordship.
3 weeks will be long, my lord. 2 weeks.
2 weeks.
2 weeks. On pre-made by the respondent, not objected to by petitioner, this is matter to 2 weeks.
Obliged, my lord.
Obliged. Your Lordship, I'm praying for time on behalf of Mr. S.N. Gupta, Lordship.
Item 12.
I beg to mention item number 12 on behalf of Mr. Sen Gupta, Lordship.
You're also not ready.
Lordship actually is ready, Lordship. But Mr. Sen Gupta
Mr. Sen Gupta was here.
Lordship, he was here, but he was not feeling well, so he has gone home, Lordship.
Prayer Smith on behalf of the Direct Conducting Counsel for the state respondent who is said to be indisposed. Prayer Smith for adjournment. The prayer made has not been opposed by the petitioner. Accordingly, the same is allowed. As prayed for, list this matter up to 2 weeks.
Supplementary cost list, item number 1.
Please, Lodge. I have served the notices through registered post, and I have filed the counterfoils also in the court.
No, but
about 5 days back.
has it
5,
been?
6 days back.
Has the notice been acknowledged?
Yes, my lord. With AD card I have sent.
AD card has not returned.
I'll follow the consignment online. I'll file a report on that.
Mr. P.K. Bora, the petitioner in person, has submitted that steps have been taken on respondent 2 to 7 respectively. However, some time is prayed for to confirm whether the said notice has been received by the said respondent, after which an affidavit of service will be filed for this court. On premium, this is matter to 2 weeks.
Obliged.
Item number 2.
Lordship. I think private respondent number 4, they have received 5 received the notice. I think it's appearing. Four,
Have you-
5, 4, 4.
4 or 4 and 5?
4.
What about 5?
4.
Is there any respondent 5?
No, Lordship.
No,
Only 4.
Only 4.
Only 4. Have you filed your power?
Yes, today itself we have filed.
What is this matter about, Mr. Sangwa?
This is regarding the compromise. Actually, I have filed just to quash the FIR saying that the private respondent number 4, because he has filed the FIR against this petitioner, saying that alleging that I was kidnapped. Then at the time of trial, they said that the respondent, private respondent, saying that by secondly he has filed the FIR, he don't want me to file the FIR against the petitioners. To that effect, they both of them has petitioner and also the private respondent, they have executed a deed of compromise, saying that the matter he don't want to pursue the matter against the petitioner, since he don't want to file the evidence intentionally, but due to some mistake the FIR has been filed against the petitioners. So he said that he don't want to pursue the matter, and then he said that that FIR was not intentionally filed against the petitioner. That was the thing. So that since the private respondent he don't want to pursue the matter, then that's why we have come before this court, since this is the matter which is cannot be this is a non-comfortable. That's why we have come before this court to quash the FIR.
What is the facts of the case?
The fact of the case is in the FIR, as for the FIR, I have enclosed, my lord, this on the 14, page 14, where it says that the FIR was filed against me, saying that on 1/1/2018, the Mitun of Risu call over, saying that they have make a telephone call to the prisoner, Then there is a veterinary garden for selling at Nokat for emergency medical treatment. And accordingly, I come to the allegation. Whole allegation is that this private respondent Paul, he has come to the alleged me that he went to that particular place for because he was called by the
Just
petitioner.
read out the
Lordship. Center for emergency treatment, and I met the Mitun at Kaljang village, where the Mitun accompanied me to his mother's house at Nokat. After having a tea, we left the house of Mitun's mother to see the veterinary garden. As such, I raided my own motorcycle as motorcycle AS so and so, and Mitun and Shekman in their bike proceeded ahead. On reaching at the place in between Nokat and Bakra at around 2 p.m., suddenly 3 armed miscreants, one of them is identified as Impu of Bakra, had stopped us at gunpoint. Then 2 armed miscreants had caught me with the help of Singan in Mitun and taken me forcibly into nearby jungle and kept in the jungle. Then 2 unknown miscreants called my wife, telling that your husband had abducted and threatening to kill me, if not to pay their demand of rupees 30 lakh only. Somehow I managed to escape from the captive on 3rd January 2018 and reached at home safely. That is the empire, content of the empire.
So the petitioners, they are named here in the FIR.
Petitioners Mitun.
Who is this Emu? So this Emu, Sengsang and Mithun are involved.
Yes, their name is appear that 2, that Sengsang and Impu name is appear. They are also petitioners here.
Also,
and next part name, my lord, is not.
Okay, so all the 3 are petitioners. Yes.
Yes, all the 3 are petitioners.
What is the stage of the case?
It seems that they have filed a charge sheet.
Charge sheet has been filed.
Lordship.
Where's the copy of the charge sheet?
Copy of the charge sheet, my lord. I got the information, but it's not here, Lordship.
Yes,
it's not there, Lordship. It's not annexed with the petition, Lordship.
No. What is the status of the case?
Lordship, I am to seek instructions, Lordship.
Find out.
Lordship, I'll do that.
If charge sheet is filed, then please file a copy of the charge sheet and as well as the copy of the case diary.
Case diary, Lordship, will do.
Let the court go into the
records
and see. Charges are very, the allegation is very serious.
Serious, Lordship.
So I'll produce the court case diary.
After 2 weeks, my lord.
Mr. P.T. Sawant, Learned Counsel for the petitioner, is present and has submitted that the respondent 4 has received notice and has entered appearance today. Mr. Learned Counsel for the has submitted that he is entering appearance on behalf of the respondent 4. On perusal of the after hearing the Learned Counsel for the petitioner and on perusal of the petition, this court is of the view that the relevant records of Receivable Para PS case number 1/2018 under section 364 under bracket A, capital A 506/34 IPC is required to be produced before any final order is passed. And if charge sheet has also been filed, the same copy of the same is also to be produced before this court. Ms. N.G. Shilla, senior GA, has submitted that the set records as called for will be produced on the next date fix. As prayed for, this is matter for 2 weeks.
Much obliged, Lordship.
Much obliged, Lordship.
Item number 4.
Item number 4, the petitioner is
Lordship, actually we have taken steps for service of notice to the respondent number 5, who is a private respondent in this present matter. It shows that the service of notice has been delivered through the postal consignment online, but we would like to confirm for the same, Your Lordship, and we would like to file our report on maybe a week, Your Lordship, because senior counsel also is severely ill, Your Lordship. Is hospitalized at this moment, Your Lordship.
Who's
Mr.
Kanta, Your Lordship.
On previous
another issue, my lord, as per the last order, the states were directed to file a copy of the proceedings. My lord, that will be a little difficult on our part, my lord. Lord, may I pray, my lord, if this honorable deems fit, my lord may call for record instead. Because otherwise, my lord, we'll have to apply for certified copy, so the process is going to take time, my lord.
There's a prayer.
Anyway, since the who's to appear, respondent?
My lord, private respondent number 5, my lord.
5.
This is the complainant.
Since is it he or she?
She.
Since she has not appeared, so we'll wait for that. As and when she appears, then the records, if required, will be called for. But Mr. Counsel for the petitioner was submitted that the report on the notice, report on the service of notice issued upon the respondent 5 has not yet come. It is prayed that the same may be awaited, and in the meantime, confirmation of such service will be undertaken by the petitioner, who will also file affidavit of service if so required. Accordingly, as prayed for, the matter will be is now posted to the next date, that is after 2 weeks from now. Next, in the previous order, this court has also directed the state respondent to file copy of the proceedings of the court in JR case number 59 of 2021. However, the records at this point of time are not required, which in any case have not been produced by the prosecution, by the state respondent. As and when the same are required, the court will pass necessary orders. This is matter of only 2 weeks.
Item number 5.
Lordship, I'm appearing for the respondent along with my junior friends. This power has been duly filed in the registry, Lordship. This may be allowed to be reflected in the national cause list.
What is this?
In terms of the last order, my lord, we had prayed for filing the orders passed by the Learned Trial Court, Lordship. We had just received the order yesterday, Lordship. Can you grant us some time to file the affidavit, Lordship?
Mr. R. Chaudhary, Learned Counsel, has submitted that he is entering appearance on behalf of the respondent and has filed his power accordingly. He, however, sought some time for the matter to be heard. In the meantime, the learned counsel for the Mr. Espanti, learned counsel for the petitioner, has submitted that in view of this court's previous order dated 10/7/2023, whereby the petitioner are allowed to file to bring on record necessary orders of the trial court in the form of an affidavit, the same could not be done so today, and some more time is sought for in this regard. As prayed for, prayers allowed. As submitted by the parties, list is matter after 2 weeks.
Item number 7.
So you have filed the...
Yes, Your Lordship, on the last date. You have supplied copies to the petitioners as well, Your Lordship.
We received copies.
You have a respondent 1.
Respondent number 1.
Mr. Learned Counsel for the respondent number 1 has submitted that the affidavit as called for has been on behalf of the respondent number 1 has been filed for this court, copies of which have been received by all concerned. In the meantime, as prayed for by the parties, this matter is to be heard after 2 weeks.
3
weeks.
Item number 8.
My Lord, I am appearing for the petitioner in this case.
Yes.
So, my Lord, the petitioner was serving as an assistant general manager of the Orchid Lake in Umiam under the Tourist Development Corporation, my Lord.
That suspension matter?
Yes, my Lord.
He was suspended and then...
No, he was not suspended, my Lord. He retired from the service on 30/11/2010, my Lord. After his retirement, a departmental proceeding was initiated against him when all the relations between the employers and employees came to an end, my Lord. And then he was made liable for an amount of rupees 10 lakh on the ground that some work was given to him for making construction of the things, and he has not done that. So on that account, out of 11 lakh, he was entitled to get by way of gratuity and leave cash and encashment of the leave. He got only 41,000, my Lord.
Okay.
So this is the case, and then the petitioner approached this honorable court, being aggrieved by that payment out of 11 lakh, only 41,000 paid to him. Finally, this honorable court directed the corporation to initiate a proceeding against him. So proceeding was initiated, but in the proceeding also the same thing remained. They said no, you are entitled to only 41,000. So being aggrieved by that, I have before your lordship by way of this petition, my lord.
Was there any criminal proceedings involving the...
No, my lord, no criminal proceeding was ever initiated against me, no. My lord, and the last time it came for hearing, the learned counsel respondent submitted that an appeal lies against this order of the leave encashment and gratuity which was not paid. So, my lord, the order was passed by the board of the directors of the Tourism Development Corporation, my lord. That is the highest body, and there is no other body where appeal can be filed, my lord. So, therefore, no appeal was filed, and this writ petition is before your lordship. And my lord, Gratuity Act provides that the gratuity amount can and no case be adjusted against anything unless the departmental proceeding was initiated for that when he is in service about the loss, if any loss is caused to the corporation. So that deduction of a gratuity amount is in complete violation of Gratuity Act.
Yes, so we'll, Mr. Sen, we'll take up the matter after lunch.
Before we proceed to the merits of the case, there is a miscellaneous application. Lordships will recall, I had pointed out last year, sometime in September 22, that there is a defect in the petition.
In the prayer.
They thereafter filed an application for correction of that date. Ideally, it should be an application for recasting or amendment of the entire writ petition, but they filed for correction. I can point out it is not a case of correction. So that miscase would have to be heard
My lord,
first,
I'm
their
not
application would have to be recast or amended, and thereafter we can proceed for hearing.
No, my lord, I'm not pressing that petition anymore now. I will just go for hearing the entire matter.
Then I can point out, my lord, there is no case in that case. They have challenged the wrong one.
Yes. Let there be hearing on the matter.
So
it's after lunch, will it?
It's after lunch. So, Mr. Siddiqui, we'll meet after lunch then?
Yes. Yes.
State is a formal party. Lord, in my case, my friend will be there.
Whoever, as long as he can open his mouth.
Because state is nothing.
State is a formal party.
It's a formal party.
State is a formal party.
The main quarrel is between the
It would appear to be so. So after lunch.
Yes.
Anything else?
There is another hearing item, item number 18. It's a criminal appeal.
Item number?
18, criminal appeal. That is the case, it will definitely take some time.
So,
Who's, you're the appellant?
So it may be come up on 24th, my lord, because accused is in the jail. So it may be come next Monday, my lord, on 24th. I'll try to finish it. Otherwise, this case will take at least 1 hour, more than 1 hour.
So 1 week?
On 24th, my lord.
Well, my friend will be out of station till 31st, my lord. He's holding the brief, actually.
31st. No, it is on 24th. 24th.
I'm leaving on 21st. He's leaving on 21st, coming back on 31st, my lord. If that period can be excluded, my lord.
So we'll take up the matter on second.
Second. Okay, ma'am.
You'll be back by 31st. So second. On pre-made by the parties. This is matter on 2nd August.
Second call, item number 8.
Yes, Lord, I am for the petitioner.
Yes.
Respondents have not. Yes. Yes, respondents.
And you can start with the facts.
Yes, my lord. Petitioner was serving as an assistant manager in the Orchid Lake Umiam, and he retired on 30/11/2010.
Yes.
So,
He was
as per
appointed when petitioner was appointed then on?
No, I don't know the date of appointment yet, but he retired on 30/11/2010 as an assistant manager of the.
On 30?
On 30/11/2010.
30/11/2010.
But after retirement, his service was extended up to 28/2/2011.
Up to
28/2/2011.
Okay.
So, in his capacity as an assistant manager, he was also asked to do some construction or renovation work of the orchid during his service, my lord.
Yes.
And as after his retirement, as per the order sheet, my lord, which is at Annexure 2, page 14.
Yes.
It says that he is entitled to total amount of rupees 11,36,224 as retirement benefit, my lord.
Yes.
Which include rupees 7 lakh as gratuity payable to him.
Okay.
Number 2, rupees 7 lakh as gratuity, my lord.
Yes.
Then, my lord, white Annexure 3, page 15.
Yes.
That for the purpose of construction work or renovation work, he was granted rupees 10,02,541 in several installments. 10,02,541.
Annexure 3.
Annexure 3, yes, page 15, my lord. I am reading from paragraph 1. Expenditure account of an amount rupees 8,31,000 have been submitted against 10 lakh. So total amount of which was given to him in various installment was 10,02,541, my lord.
Okay.
For renovation as well as for the departmental works. So which according to the corporation responded, my lord, he did not submit, the petitioner did not submit a proper account for this. Same thing. About that 10,02,000.
Okay.
And out of that 10,02,000, he submitted the account for 8,31,441. That was the allegation.
Where is it?
I'm reading from paragraph 1 of annexure 1.3. What is there? 1, 2, 3, 4 paragraphs are there. It says that expenditure account for an amount of rupees 8,31,441 only have been submitted against the advance of rupees 10,02,541
Yes.
taken as back on 30th October 2000 as per detail below. So this means he submitted the account of 8 lakh against 10 lakh, which was granted to him for renovation work. So that is why whatever he was to get, he was supposed to get, I submitted earlier, he was supposed to get 11,36,224 as a retirement benefit, my lord.
Okay.
So entire amount of 10,02,000 was deducted from that because there is no proper account according to the corporation. So he was given as a retirement benefit only 41,139, my lord. As per page 16, last but one paragraph. Page 16, last. In view of the above, a sum of rupees 41,139 shall be payable to Sri Kamal Lindo, ex-assistant manager.
Yes.
My entire amount, including gratuity, was adjusted against the so-called so-called account, which I could not submit as per their allegation. So, White annexure 4, my lord, page 17. A check was forwarded to me for 41,139.
Yes.
So which I refuse to take, my lord. So, my lord, as per annexure 5, page 18,
yes,
I was informed by the managing director that the board has ratified this action taken by the authorities. That is to say, he is entitled to only 41,139 and the rest has been adjusted against that amount which was paid to him earlier. So paragraph 2, it says, in accordance with the above ratification of the board, the necessary check of rupees had been sent to you.
Yes.
And paragraph 1 says, with reference to the subject cited above, it is stated that the board of directors in its 127th meeting held on 5/7/2011 has ratified the office order number dated 11/5/2011 on gratuity and encashment of earned leave for payment of some rupees 41,139 after necessary adjustment of advances taken by you from time to time. These adjustments have been made against the dues payable to you on account of gratuity and encashment of earned leave, which is rupees 10,43,600. So almost my entire amount of retirement benefit was adjusted against the so-called expenditure made in the renovation. Then, my lord, being aggrieved by the action of the corporation, the respondent corporation, my lord, I approached this honorable court by a writ petition at annexure 6, my lord, which was disposed of on 10/4/2014. Page 20, annexure 6 is the order, my lord.
Yes.
It's paragraph 8 at page number 23, my lord.
Page 22.
Page 23, paragraph. It says that therefore I am unable to record any reason to justify that the respondent was right in adjusting the post-retirement benefit of the petitioner against the amount sanctioned. Hence, the respondent is directed to release the post-retirement benefit of the petitioner within 1 month from the date of receipt of this order. However, the judgment and order passed by this court will not prevent the respondent from taking nature courts of law if it is really a genuine case of misappropriation, but it should not be out of personal vendetta or revenge. With these observations and direction, this instant writ petition is allowed. But after this order of this honorable court, they issued a letter of explanation to me on 22/5/2014, White Annexure 7, page 24, my lord.
Yes.
So this is an explanation as regards the charge framed thereunder pertaining to the expenditure of an amount of rupees 10 lakh, also given to you between 6/9/2001 to 18/4/2008 for repair and construction work of the Orchid League. This explanation was given to me. And thereafter a departmental proceeding was initiated, my lord. White Annexure 8, page 26.
Yes.
And this is the final report, my lord, on 20th August 2015. After proceeding, this report was forwarded to me as a final report. And in this final report, my lord,
this is the final inquiry report.
This is the final report of the proceeding, my lord.
Yes.
At page 29, the last two paragraphs, my lord.
Yes.
Last two paragraphs. Thus, on observations made aforesaid, I am of the opinion that Sri Kumar Lindo has failed to satisfy this inquiry as regards the charges framed against him. Therefore, in view of the above observations and the fact that even assuming but admitting that the works were executed by him, they were done in total violation of the practice and procedure adopted by any government servant in general, and a government servant of office teacher in particular being the assistant manager with many years of dedicated service. Therefore, it is my considered opinion that the amount that has been sought to be deducted from the retirement pensionary benefit of Sri Kumar Lindo duly deducted. It is further made clear that even though the gratuity of an employee is not usually deducted or withheld from an employee, in this case, besides the delinquent service not being gratuitous, is being deducted as there is no other way in which public money, as has been proved to be misused by the delinquent, be recovered from him. So, in this way, my entire gratuity amount was deducted or adjusted against the so-called misappropriation, they call it. But now, my lord, if my lord comes to additional affidavit filed by the respondent.
Dated? Additional affidavit dated?
It was filed on 25th November 2019.
Okay.
Additional affidavit, my lord.
Yes.
So, there is at page 35 of this additional affidavit, my lord, there is a spot verification report.
Page 35?
Page 36.
36?
Yes, 36.
Spot verification report.
Yes, my lord. So it says, number one, for renovation of 16 bathrooms, 3,23,000 was sanctioned, out of which he spent 3,22,998. And it specifically says the renovation of 16 bathrooms have been done in the year 2000 to 2016. 16 bathrooms were again dismantled and renovated as confirmed by Shri K.M. Singh, accountant, OLR, and Srimati E. Bufanang, chambermaid, OLR. So it itself says that out of 323, he spent 322. That is the spot verification report. Next, my lord, repair of wooden railings. Sanction amount is 7,500 and is spent 7,629. It says inspected and still exists with repair and renovation from time to time. Third is, my lord, furnishing of room number 109 and 1010, for which 7,900 was received by him and 7,968 were spent for blankets, curtain, doormats, etc. were procured as confirmed by Srimati E. Bufang. Combermaid OR leach on the chimney place still exists. Then comes number 4, repair of 2 public toilets. Amount received by him was 50,000, spent 50,081. 2 public toilets were constructed, one for the ladies and one for the gents, as confirmed by the staff in position. These toilets were dismantled in the year 2010 and new toilets constructed thereafter. Then, my lord, come to number 5, page number 37. This is about the main gate and signboard and painting, etc. 3,000 was received, 3,020 was spent. Main gate and signboard, painting for water sport displaying the timings, ticket rate, etc. still exist. Then furnishing of room number 109 and 110, 62,041 was received and 62,041 spent. For sofa set along with chair, writing table still exists, but furnitures are being transferred from one room to another as per needs arises, as confirmed by Sri Biflang in OLR. Next is number 7, furnishing of 8 rooms in the new building, room number 201 and 208. 3,55,000 was received by him and 365 was spent for furniture, that is bed, chairs, writing table, wardrobe, TV table, bedside table, including mattress, pillow cover, blanket still exists. One room was checked and other rooms could not be checked as they were all occupied by the guests attending the conference on 12/6/2014. Then number 8, purchase of cutleries. 8,000 was received and 8,640 was spent. The items could not be checked due to wear and tear over the years. Then construction of stores. 15,000 received, 15,079 was spent. In place of the old store constructed under the supervisor of Sri Kumar Lindo, a new store was constructed again in the year 2011 for grocery provision, etc. As confirmed by Sri K.M. Singh, accountant OAR. The bar stone constructed by Sri Kumar Lindo still exists. So, my lord, this observation report shows total that 8,39,751 was spent. This is the total of this observation, is that 8,39,751 was spent by him out of 10 lakh he received. This is accepted position, admitted position in that additional affidavit. So how could they deduct the entire 10 lakh? At best, they are disputing only 2 lakhs. And they say 8 lakh has been spent, still they have gone with that, my lord. Then, my lord, this report was never ratified by the board. And it just came as a support to that ratified order of where 10 lakh was deducted from my whatever I had to receive on account of gratuity and encashment of my leave, my lord. Now, my lord, if I come to the law, that whether a gratuity amount of an employee can be deducted, my lord. So I am reading from Gratuity Act, my lord. Section 4, subsection. Section 4. Section 4, subsection 6A.
Yes.
Just may I read, my lord? The gratuity of an employee whose service have been terminated for any act, willful omission or negligence causing any damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss so caused. Means, my lord, that only if an employee's service has been terminated because of loss caused to the employer, then only it can be deducted. Otherwise, under no circumstances, gratuity can be deducted from the employee's fund. So therefore, the deduction of rupees 7 lakh admittedly by the respondent is entirely without any legal authority, my lord. It does not stand to the test of law, my lord, and it is request to be quashed. And again, 8 lakhs rupees has been shown in the observation that the work was done. So under how they came to the conclusion that I have not used the money which was given to me for construction. Only they came with the thing that according to the standard, the receipts were not submitted by the petitioner to the employees. My lord, but the proceeding was initiated. The petitioner was no more in the service of the employer, that is the corporation. So there exists no relation of employer and employee between the petitioners and the corporation, my lord. So he was not in a position to produce any file, any document. How it could be possible for him when the entire thing was handed over by him when he handed over the charge. So the proceeding itself is illegal and without authority of law. The person who is not an employee of the corporation, how a proceeding could be initiated against him, how his gratuity amount could be deducted, and how, despite observations made by them that he has made the construction work, it could be deducted. So therefore, I pray that this order of deduction may be quashed. And so far as the stand taken by my learned friend that I should have filed an appeal, my lord, the highest authority of the board is of the corporation is the board. When the board ratifies something, where I will go? There is no place to go for appeal. Therefore, I had no other option but to come before your lordship by way of this petition. That's it.
Please, your lordship.
Yes.
Before I start again, may I just again draw lordship's attention to the pending miscase. May lordships kindly dispose of that miscase on the ground that they're not pressing for it, because then I'll have a consequent. My submissions will follow from that.
No necessary order will pass.
Lordship. So miscase they're not pressing, that will be disposed of. Now, lordships have noticed the facts of the case. I won't enter into merits immediately. The first deduction order was passed on 11/5/2011, which came to be challenged by the petitioners by way of WPC 330 of 2012. By that WPC, this first adjustment order was set aside. Thereagainst, the respondent corporation preferred a writ appeal 29 of 2014. Now, kindly have that writ appeal, my lords.
Is it on record?
Yes, my lords. They have not enclosed it, but it's part of my affidavit. The affidavit filed in the month of June 2016.
Okay. June or July?
So there are two affidavits that the corporation has filed. The first affidavit in opposition, and then there was a additional affidavit.
I think the first one is in 22nd July.
I apologize. There would be July.
2016, yes.
Upon filing the writ appeal, a stay was granted, which is at page 25 of the affidavit.
Page 25. Yes.
I'll read from the third paragraph onwards. This writ appeal is directed against a judgment and order dated 10/4/2014 passed by learned single judge in WPC so-and-so, whereby the post-retirement dues has been directed to be released within a period of 1 month. Admit the appeal, having heard learned counsel for the parties and after going through the impugned order, as an interim measure it is directed that till next date of listing, release to the extent of 10,02,554 after the post-retirement dues is stayed, it is made clear that the impugned order in respect of the rest of the post-retirement dues is not interfered with. Now, kindly then have page 15.
50.
1-5.
Yes.
This is the order dated 9/3/2015, whereby the writ appeal was disposed of. I'll read from the 4th paragraph onwards.
Yes.
In view of the fact that inquiry report has already been submitted, according to learned counsel for the parties, cause of action does not survive. Hence, this matter, having been rendered infructuous, can be disposed of, but that nevertheless it would be open for the parties to challenge the inquiry report in case of any grievance in respect thereof before the appropriate forum. Kindly take note of this, my lords. Between the time from the passing of the judgment by the learned single judge, whereby we were given the opportunity, the authority to initiate proceedings in accordance with law, we initiated proceedings and we informed the learned division bench of this honorable court. Now, this was the direction that the inquiry report can be challenged. Kindly take note of this, my lords. Nothing beyond that. Now, thereafter, an explanation notice was called for from the petitioner on 25th of May 2014, which my learned seniors referred to. And following that, he participated. He filed a reply, he participated in the proceedings, he cross-examined witnesses, and finally there was a final inquiry report dated 20th of August 2015. Now, the learned division bench of this honorable court had directed that the inquiry can go on, there was nothing wrong with it, and if at all they were aggrieved, they could challenge the final inquiry report which had been submitted. Now, kindly see the prayer. That is what the defect with this petition is, my lords. The prayer is at page 10 of the writ petition. If lordships have it, may I just read?
Yes.
In the premises aforesaid, it is most respectfully prayed that your lordships would be graciously pleased to set aside and quash the orders dated 11/5/2011 and 22/5/2014. My lords, kindly note, 11/5/2011 was the original notice of adjustment which was challenged before the earlier round of litigation, and this was set aside by the learned single judge. So there was no need for them to challenge this order. This is one. The second order that they challenge is 22/5/2014. This is the explanation which was called for. They are challenging that. But they participated in the same inquiry all throughout for 2 years. So I fail to understand what remains in this writ petition. The final inquiry report has not been challenged till today. Now, they've already said they don't want to pursue the miscellaneous application. Nothing remains in this writ petition. They've not even challenged the inquiry report. It has become final. They ought to have challenged that. Nothing survives in this writ petition.
Even the inquiry report per se
Lordship.
would not affect them to that extent. In as much as, see, if we talk in terms of quantum,
Lordship.
it is only to the extent of 8 lakhs or so, which ought to have been adjusted against the total dues that. So, I believe the stand of the petitioner is this, that he is due to get 10 lakhs or 11 lakhs, whatever the case may be, for which 8 lakhs should have been subtracted, and that amount should have been given to him.
So, Malos, that would be a subject matter of the final inquiry report. Here, what is under challenge is the show cause notice.
This is not the final inquiry.
No, my lord, that's what I'm saying. Kindly have the prayer again. 11/5/2011 is what was challenged before the learned single judge in the first round of litigation. That was set aside. 22/5/2014 is a show cause notice. That is what they've challenged. The final inquiry report is not under challenge. The final inquiry report is dated 20th of August 2015, not under challenge. The learned division bench of this honorable court had directed, if you have any grievances against the final inquiry report, you're welcome to challenge it. You are at liberty. They did not challenge this. Now, I pointed this out last year.
Okay, that inquiry report was referred to. Was it referred to by the petitioner?
Yes, my lord.
In the writ petition, they make a reference to it. They make a reference to it, but they do not challenge it. After this was pointed out, after I pointed this out, that the prayer cannot be modified in this manner.
I understand.
So my submission even last year was this prayer cannot be modified simply by the court, because what is under what they're trying to say here is that the corporation did not have the jurisdiction to proceed, And on that premise, they've challenged the show cause notice. But the question remains, the show cause notice, if they wanted to challenge on account of lack of jurisdiction, they could have challenged it immediately upon receipt. So the day they received the letter of 22/5/2014, they could have challenged that letter very well before this honorable court. They did not. They participated in the entire inquiry, and the inquiry culminated in a final order. Now, there before this honorable court, not challenging the final order, but only challenging the show cause notice, and also challenging a letter which has already been set aside. So, which is why I was insisting that if lordships, if they do not press the miscellaneous application 188, this does not survive anymore, because the purpose of the application, the purpose of the miscellaneous application was to substitute this date of 22/5/2014 with the date 22/8/2015, which is the date of the final inquiry report. Now they're saying they don't want to pursue that mis case. So my question is, how does this survive? So they might have made a reference, and kindly see the writ petition. A mere reference has been made that an inquiry report has been passed. That's all. They're not pointing out what is wrong with the inquiry report.
What is right? Yes.
They need to make some submissions as to what is wrong with the inquiry report. Point out what is the fault with the inquiry report. No submissions have been made. So my question is, what survives, my lord? What sort of relief would lordships grant them? I had pointed out that this prayer is defective. So immediately because of that, they filed an application, and in their application they have said that this was on account of a mistake, a typographical error. So how do they explain the delay? So if they want to challenge the order of 22/5/2014, which is merely a show cause notice, why did they prefer this writ petition only in 2016? No explanation for the delay. So that question will have to be answered by them.
What about the second part of the prayer?
Well, but this has already been decided, or part of it. A part of it has been decided by the inquiry report. So that inquiry report has become final. So whatever their grievances may be, their grievances have to be against the inquiry report, not against a show cause notice. And Lordship, I had raised this last year in 2022, pursuant to which they filed the mis case. Now they don't want to pursue the mis case. So I don't think there is any reason for lordships to go into the merit of it unless and until they can reconcile this prayer.
See, Mr. Sen, this inquiry report has been brought on record by you.
Lordship.
So what prevents the court from taking judicial notice of it?
My lord, because it is not under challenge by the petitioner. Petitioner has to challenge. I can bring on record several things, but they must challenge it. It is not under challenge. They had the opportunity to challenge it because I pointed this out. I pointed out the defect. They had the opportunity, so they filed a mis case. Whether that mis case is right, wrong, that's a different issue. But they did file a mis case. Today they're saying they don't want to pursue the mis case. They are satisfied with this petition as it stands. And the prayer is completely misdirected. Completely misdirected. Lordships can just go through the entire petition. They don't make a specific challenge to the contents of the inquiry report. What is wrong with it? Whether there has been a violation of principles of natural justice, whether there has been non-adherence to the rules. Nothing whatsoever. They're only directing their challenge to the show cause notice. So if lordships do interfere, lordships will only interfere with this show cause notice of 22/5/2014 because the notice of 11/5/2011 has already been set aside in the previous proceedings. So even if this is set aside, let's assume for a moment, the inquiry report still stands because that has not been challenged.
See, what was referred to by Mr. Siddiqui, the spot verification report?
Well, that pertains to the final issue.
Yes.
The merit of the matter. But we're not on the merit of the matter yet. If the inquiry was conducted and They have not challenged the final report. I don't see how we can enter or we can go into the ambit of the inquiry report.
Okay, let's assume they have not challenged the inquiry report, but the inquiry report is on record now.
True.
Before you.
True.
Before your office, and this is the finding of the inquiry officer.
Lordship.
To the extent that an amount of 8 lakhs odd have been actually spent.
Lordship.
Isn't it so? So to that extent, the steps that should have been taken by the corporation would be that the amount of 8 lakhs should not have been deducted from his retirement benefit or whatever. But that was not done. So now...
Well, again, I would say, at the sake of repetition, that is entering the merit of the issue. Again.
True. See,
only
what
entering the merit.
I'm saying, see, okay, let's leave aside this case as it is.
I understand.
What would have been your
let me just study that on that issue, because my lords, I am here only on this very technical ground.
You may be, but Mr. Sen, please.
No, I understand what lordships are asking me.
As an officer of the court,
let me just study that issue.
You have to be fair to all.
Absolutely, I understand. Let me just study that aspect.
The petitioner is due.
True.
To the extent of that 8 lakhs or so.
Lordship.
I think that would satisfy you. Leave aside.
Let me examine that, my lords. I'll also have to take instructions whether they're willing to concede to that extent.
No, but
if they're willing,
it's in black and white.
Let me examine it. Let me just examine it. But I was here today, number one.
Yeah, technicalities will be there. That you see, sometimes you have to see what is law and what is justice.
Correct.
So, prima facie, I would see that the petitioner would be entitled to certain. He may. You see, we are not going to the issue of whether he has, really spent the money or not, whether he has misappropriated, or let's not go into that issue. But the fact remains that an inquiry has been conducted, and this is the report.
Lordship.
So the consequential action should have been taken by the department, which probably may not have been done. Had it been so, he would have admitted.
Lordship.
Get instructions.
I will.
And see if it's due, then concede and get the matter over and done with.
Let me examine that, my lords.
Mr. Siddiqui?
Yes.
We'll wait for their...
Yes.
How long?
They'll have to sit, the board will have to sit over this matter, my lords. So
2 weeks.
I can't.
3 weeks.
Perhaps 3 weeks, my lords.
But come with a positive.
Let me examine this.
He has
Apparently, the board stand is that there has been very serious pecuniary loss caused to it.
Whatever.
So, to what extent, let them examine it. It's not for me.
Okay,
I'll put it across.
now we are only on the quantum.
Lordship, I'll just put it across.
Please.
But this is without prejudice to my rights to proceed on the issue of the technicality that I've raised.
That apart.
All right. But also, well, just to safeguard my arguments, Lordships will kindly record that they're not pressing that 188 in this case. Because that would have a serious bearing on the case, my lords.
Can you this case more? 181.
Well, my lord, let it remain open. That petition when they are taking time for getting instructions.
This back and forth will not help, my lords, because they've already said they don't want to pursue it.
No, Mr. Siddiqui,
I started with this.
Mr. Siddiqui, the court is trying to help you. At the outset, you have conceded that you are not pressing this matter, so let it be so.
Okay.
Now you would rely on the good offices of Mr. Sen to help you. Otherwise, nothing can be done.
No, whatever has come from the court, I'll convey to the department.
Please. Upon the parties being called upon to be heard in this petition, in this dismissed case, Mr. A.S. Siddiqui, learned counsel for the learned senior counsel appearing for the petitioner, has submitted that the petitioner is not pressing this petition. Accordingly, petition is dismissed as not pressed. In case parties have been heard in this matter, however, on a query by this court relating to facts which may not directly be related to the issue contested by the parties. However, for ends of justice, the court would impress upon the learned counsel for the respondent MTDC, isn't it?
Respondent number 2, my lords.
Respondent number 2, MTDC, to seek specific instruction and to report before this court on the next date fix. Let's this matter after 3 weeks.
I'll leave it.